We're the moms who ask the questions, digging deep, no second guessing. From the school run to the crime scene, truth and chaos, we're the dream team. Bad Kids Club, yeah, we ride or die. Sad eyes sharp and our standards high, brought together by FKR. Now we're taking truth real far, and we're just getting started. Talk time with Amy, Boston, and Kelly, spilling facts that hit your belly. Partners in crime, fueled by conviction. Moms on a mission with sharp intuition. Talk time, we're calling out lies with caffeine, chaos, and side-eye vibes. It's raw, it's real, it's how we vent. Leaning close, let the reckoning commence. This is Talk Time with Amy, Boston, and Kelly, where the tea is hot and the truth cuts.
All right. Ms. Hamilton, your matter is continued to August 25th at 2 p.m. for a bail hearing. Habes.
Hello, my peeps. I have the Zoom going. It will be on. Aidan did say it will probably start a few minutes late, so I'm just gonna let the Zoom play. Okay, guys, while they're at sidebar, I figured I'd jump on and say, hey, thanks for joining us. Turn this off. Totally heard myself in the background. How's everybody doing? Come say hi if you're here. If you're not, if you're at X, come on over to YouTube at Talk Time with Amy, Boston, and Kelly, and come hang out with us. So, been a crazy day. Just been running around. Doctors don't want to do their jobs. Trying to get that done. Pain in the butt.
what we've talked about is defense investigator and the representative from the Commonwealth that'll also inspect will coordinate a date, contact Mr. Liu, that's the owner of the property, and it can be inspected at that time.
Okay, that's fine.
So Judge, I'd ask the court to allow the order. So the landlord, my private investigator spoke with a landlord who would be cooperative, as would one of the two tenants. It appears the other tenant may be less cooperative. So with the court order, the Quincy Police could certainly get us in to view it.
I just ordered it.
Awesome, Judge. Additionally, I went to the clerk's office to get copies of paper 165, 179, 180, 181. They said there was no order that could be released to council. Could I ask that order be made?
What are they?
Numbers again?
I have to have them in front of me. I don't have them all memorized, unfortunately.
Juvenile probation record.
Yes.
What are they?
Oh, so they're,
The juvenile probation recs, 165.
Yeah, you can look at that.
And I would just ask Sherrod that the cop be able to inspect the copy, whatever gets produced as well.
Yeah,
Thank you.
it's all allowed.
Thank you.
That's all those records you saw at the last time.
Yes, Your Honor.
I remember that. Yeah, all right.
And lastly, Your Honor, the Commonwealth has a protective order which it intends to file today before providing counsel with some other records we have received. If defense counsel signs it, then I would ask Your Honor to review and sign as well. I
Yeah,
can
sure.
send up
Have you shown it to Mr. Sergeant?
Yeah, I'll sign it.
briefly, but
Why don't you sign it, I'll sign it, and then we'll get done.
if you're on mute, please mute, if you're on Zoom, please mute your cell phone.
I believe, and I believe
And then motion to, motion to town. Hey, how you doing?
Thank you. Okay.
Oh my God. That's great. The Norfolk Superior Court, I'm sorry, the Essex Superior Court closed because the air conditioner was. Yeah. So my brother and Joe on Monday.
You got the replacement contract,
Yes, we did, yeah.
and you went through it and everything's there?
Well, no, I don't think it's from you, but there's a attachment that expired.
The links are invalid.
The links are gone or dead or whatever. You presume they expired.
I presume that's the case. So they're going or dead for us as well.
Well,
It's a problem.
No,
No, they probably have a set of things. They're all
we probably have what set? Right, yeah, lost 7. I don't put them now, there's lost 7. Yeah. Right.
Good afternoon.
Good afternoon.
Council, are we ready?
Yes. Thank you. Sit here?
Yeah.
Would you mind talking at the podium, because I can't hear you half the time when you're talking
Sure.
this way to the judge. It's my vacation.
Sure.
I know.
You're taking away my advantages here.
All right.
For the record, before the court, numbers 4, 5, and 9, Commonwealth versus Aidan Kearney, 23 CR 313, 24 CR 43, and 25 CR 88. Kearney is present. If the parties could please identify themselves for the record.
Good afternoon, Your Honor. Robert Cosgrove for the Commonwealth.
Good afternoon. Timothy Bradle for the defendant, I bet.
Nice to see you.
Nice to see you.
For the defense.
How are you? I'm Mr.
Healing
Kearney.
County Judge, this is my client Aidan Kearney in the middle.
Good afternoon. All right. What do we have today?
Well, we have a bit of an agenda here for you, Your Honor.
Go right ahead.
Can I go through?
Yeah, go ahead.
Thank you. Your Honor, we're back here on discovery issues that have been going on. As you know, the automatic discovery certainly is due at or before the pretrial conference, which was like over a year ago. And we've been going back and forth with this. And if you just peruse the docket, I'm not going to go through it because I know these kind of tedious discovery hearings are awful for everybody. But if you peruse the docket, you'll see all kinds of motions to compel. Yeah, sure.
Yeah, go ahead, Mr. Bradle. I'm sorry, I left my notes. I took some notes.
No, that's okay. I appreciate you taking.
Yeah, and then I left it in the lobby. So.
We're willing to wait for you, Your Honor.
No, Mr. Summers went to get it. Takes good care of me. Mr. Bradle, go right ahead.
Thank you, Your Honor. So if you peruse the docket, Judge, you'll see all kinds of motions to compel, and it's just not happening. It's just not happening. So putting the issue of, whether it's an intentional thing or a, just not getting it right kind of thing, nonetheless, we need these items. They're exculpatory. If this was just regular discovery, I might ask for a ruling that the Commonwealth may not use certain items they haven't given us, but this is exculpatory stuff that we need. One of the most important highlights, Your Honor.
So I went through it. These
Yeah,
are
go
what
ahead.
my notes are. You want access to different items in a form that you can see on your computer, right?
Right. We can't open what we got.
You want something about somebody that's allegedly a government agent, right?
Yes.
You want digital copies of some documents. You want videos that were taken by the Commonwealth of the rolling rally. The Brady list, right?
Yes.
All right. Is there anything else?
Yes, Your Honor. Go
ahead.
There's a whole host of items.
Yeah, go ahead.
So the first thing, Judge, is that I don't know if you heard, but it was all over the media, but we got 4,000 blank pages after we were here last time when the Commonwealth said, oh, we gave them 5,000 pages. 4,000 were blank. And now the Commonwealth wants us to give back the thumb drive that has some things on it minus the 4,000 pages. So last time we gave something back, we never saw it again, and they still don't want to give it to us. And that's the Gattani extraction.
Yeah, I read that.
The redacted extraction.
There's another motion, a pro se motion on that.
Yeah. So, I'm sorry, go ahead, Judge.
No, go ahead.
So it's been like 9 months and we don't have the redacted extraction that the Commonwealth promised me. I look back at my emails on July 9th, 2024, saying it would be ready for pickup. And it just never happened. So now they're apparently doing a 180 in their filing saying, go get it from your friends, Mr. Kearney. And I don't really understand that. I don't think it's a serious response. And the Commonwealth owes us the discovery, the redacted discovery. And I ask that you order that forthwith.
Okay, let me hear from Mr. Cosgrove on that.
All right. Many of these issues, Your Honor, I addressed in my filing. I had been working diligently to get Mr. Bradel the discovery, despite some obstacles. If Your Honor would be kind enough to go through the list that you just went through with Mr. Bradel one by one, I will respond to them individually.
Yeah. Commonwealth video of the rolling rally.
All right, the Commonwealth has provided at least 2 copies of the video to the rolling rally, one of them in the format specifically requested by Mr. Kearney. The last time it was provided was, I think, about 6 months ago. The first I heard that he was having a problem with it was the motion that he filed on the last date. As I indicated to Your Honor in my filing, I had notified Mr. Bradel of dates that he could come over to the office and we would attempt to show him the video and resolve that, which was his suggestion in the first place.
Oh, yeah, I remember reading.
And I got no response.
Mr. Bradel, when are you going to go over to see Mr. Cosgrove and look at this?
So, Judge, that's a separate category, okay? I don't think, you know.
Let me start with this. When are you going to go over to Mr.
Yeah,
Cosgrove?
we'll be happy to go over it. We're not concerned with that aspect of it. We're concerned with the stuff that they were supposed to give us. We can put that aside, the stuff that they tried to give us.
Right.
And it didn't work, you know, that it's not the right format. Nobody can open it short of Bill Gates. And, you know, that stuff, I'm confident with our team, there's some really good computer people on our team that can figure it out. And we've said to them, just do this. And they haven't done that. So if we have to go over there, fine.
Mr. Cosgrove has said to you, come to the office.
Yeah.
We'll do it.
Yeah, we will, and that's not what this hearing is about as far as we're concerned. There's a ton of other stuff that doesn't require that.
That's fine. Go ahead, Mr. Cosgrove.
And the second item, Your Honor?
Let's see. I have the Brady list.
I had indicated to Mr. Bradel that I would provide that information 30 days before evidentiary hearing or trial, whichever came first.
I think, and then you said you'd give it to him by September 3rd in your memo?
Yes.
I'll order that. I'll order you to give it to him by September 3rd. So that takes care of that.
What's next, Your Honor?
Okay. Let's see. We have, I think we get to then the, supposedly somebody working as a government agent.
Oh, that would be Catherine Peter, I believe.
Yeah. All right. So tell me about that.
Well, Catherine Peter is relevant basically to the Lindsay Gattani cases. She is a former employee, as I understand it, of Mr. Kearney. He and she had a falling out over issues that don't concern the Commonwealth long before this case was originated, and basically exchanged negative posts about one another. From time to time, she has emailed usually Lieutenant Tully.
No, I'm not interested in the specifics, but more so, I think in your filing that I have in front of me, you have replaced the defective thumb drive, am I correct?
Yes.
Mr. Bradel, do you have that?
We do, Judge.
All right, so then that's taken care of.
Yes.
All right, great. All right, that's good. Provide.
Yes, sir.
Okay. So then we go to the next one, which is a digital copy of all communications from District Attorney Morrissey to civilian witnesses. And it gives a list of names. And then it says that from Mr. Bradel's point of view, that the Commonwealth hasn't provided complete discovery. Go right ahead, Mr. Cosgrove.
Well, I don't know what he thinks he's missing, number one. Number two, what the Commonwealth is obligated to do under the rule is to provide statements of witnesses.
Yeah.
It's not obligated to provide the electronic information which may accompany it, any more than when it turns over a photograph, it's required to provide who the photographer was, that sort of information. I think this information, I have an inquiry in, would be difficult to access and provide. The Commonwealth has spent literally days assembling statements of witnesses, which are voluminous because it includes all kinds of emails that the witnesses have made to the district attorney's office, and those have been harvested by means of an electronic system called ETOS by using term searches, and then people have gone through them and screened them, and I have screened them for compliance with Rule 14, generously construed, and those have been turned over. I can conceive of certain situations where electronic information might be exculpatory, and I think that's an issue that can be raised on a email by email basis. For example, if it were, if you had an email from somebody and their location at the time that they sent the email undid or provided an alibi or something like that, that would be exculpatory. It should be turned over. But in the ordinary course, all this does is provide information to the defendant that is irrelevant and is not required to be turned over. I think these are issues that can wait for a determination as we approach trial as to whether something is material and admissible.
Okay. Mr. Bradel, can you comment on that?
Yes, Judge. So this is the metadata issue?
This is the individual, well, it's a digital copy of all communications from District Attorney Morrissey to civilian witnesses.
Oh, yes. Okay. Thank you, Your Honor.
And it lists a whole slew of people.
Sure. So, Judge, the Commonwealth in this case has been going to the mattresses, so to speak, to keep this stuff from us. And meanwhile, the employer of the special prosecutor has released a FOIA of these items, which, just to move ahead for a sec, the fact that they released all this stuff pretty much obliterates this Commonwealth's impoundment privacy argument. But while we've been going back and forth with all this court time with keeping things secret from the defense here, the district attorney's office released 4,000 text messages from Trooper Tully as a FOIA request to the general public. while we, as defendants in a criminal matter with constitutional rights attached, have got nothing. So it's out there, this FOIA request from the employer of the special prosecutor, but not from this special prosecutor. So in terms of the integrity of this stuff, we need the special prosecutor here to give us the items in the context of this case.
The 4,000 text messages, were they
Yes.
related to this case, Mr. Bradel, or related to other cases?
Well, it's relevant to the Reed matter, to our matter, it's all the same alleged victims. It's actually emails, not text messages. I'm sorry. But it's 4,000 pages of stuff that we've been wrangling back and forth about. Meanwhile, the district attorney's office releases them in a FOIA like a week ago. That has been bandied all over media while we've been trying to get this stuff for a long time.
Okay. Let me
So
go to Mr.
yes, it's a good thing that we're getting it,
Yeah.
but we need the government, in this case, to give us what they are contending is that stuff.
Let me just go to Mr. Cosgrove for a minute. Mr. Cosgrove, were you aware of that?
The short answer is no.
Yeah.
It's, I guess, part of the price of having an independent special prosecutor, Your Honor. I don't work out of the office. I haven't been to the office within the last 2 weeks, I think. So I was not aware of that. I was aware that 12 news organizations had filed FOIA requests for information in the Karen Reed case.
Sure.
But I wasn't aware of what particularly had been released. I'll look into that.
Okay.
I will say that when Mr. Bradel says he's received nothing, that is flatly untrue.
Okay. All right.
I agree, Judge. We got about 200 and something pages out of what was supposed to be 5,000.
So I remember the last time we were here, Mr. Cosgrove, you had said that there were 5,000 pages, or some large amount of pages. I'm not going to say 5, it might have been 3.
It was about 5,000. I think it was 4,700 and something.
Okay. Was some of that blank, or?
Well, the only information I have with respect to that was a letter from Mr. Bedrow that arrived 5 days later, complaining that the bulk of those pages were blank. I do not know why they would be. I haven't been able to figure out why they would be. As a result of that letter, I went back to the DA's office and sat down with one of their electronics people and had them make an entire new copy off of my laptop. And I actually added a little material that had come in since, provided by one of the prosecutors in the Reed case. But the bulk of it was the same 5,000 pages. I then went through that personally with the electronics person sitting by my side and ensured that each and every page was reproduced on the copy that I sent to the defendant. So
Have you sent that to Mr. Bradel or Mr. Bedrow?
I've sent it to Mr. Bradel, and I'm informed that he's got it, so I'm not quite sure why we're still talking about it.
Got it yesterday, Judge.
All right.
So haven't been able to go fully through it.
Yeah, no,
but
sure.
It supports all sorts of other things that we're here for as well.
All right. But you did get it. Okay.
Yes.
All right. Then the next thing would be, the next thing I see, and Mr. Bradel didn't think this was much of an issue, was the video of the Commonwealth surveillance from the rolling rally. Has that been?
I think we addressed that, Your Honor.
We can go to the office, and I'm sure that.
Yeah, okay, so that's fine. So that takes care of that, that's
Thank
good.
you.
And then,
Judge, before we move on, I don't want you to go too far off of this. So I know it's tempting to think that these 4,000 blank pages is the same thing as the 4,000 FOIA. They're different. So the first thumb drive thing with the 4,000 blank pages has been remedied, okay? But the FOIA thing that should have been given to us has never been given to us, but they're responding to FOIAs about it to everybody but Mr. Kearney. So
I
it's
get
like,
that. But Mr. Cosgrove says he's gonna look into that, and I'm sure he'll give it to you.
okay, so I just didn't want you to think that was the same
No, no, no,
4,000.
no, I
Coincidentally,
didn't
it's
think
different.
Yeah, I didn't think that.
Okay.
All right, I didn't think that. All right. Then I think it's just am I correct, Mr. Bradel? Is that the list or are there more?
There is more, Judge.
Yeah, tell me the rest.
All
Go
right,
ahead.
sure. So within the thumb drive, the thumb drive that was just remedied and given to us, there's all sorts of attachments, and we have a disagreement about this. There's all sorts of attachments from Ms. Peter to the state trooper team and Mr. Mello, I believe it was. I don't think Mr. Cosgrove was on the case then, where Ms. Peter is repeatedly providing attachments of things to the state troopers, and she's literally working on videos for the state troopers that were exhibits in the grand jury.
Let me just hold on for a second. Mr. Cosgrove, is that part of the 5,000 pages?
Yes.
All right, so then there, you got it at least.
I wish I could say we did have it.
Yeah.
If you hit the attachment, you get that message saying nothing's there. I printed out a few of them, but I'm sure you can just take my word for it, Judge. It says no attachment, nothing found, et cetera, et cetera. They don't come up.
So that's a technical issue. I'm sure you can figure that out.
So I think it's worse. I think it's it's actually a lot. Sorry, just.
Drove it again. He said you are good to go.
Yes. All right. I'll see you shortly.
Okay.
Thank you very much. See you in a minute. Thanks. Bye.
Bye-bye.
Hi.
So, Your Honor, it's actually.
The wonders of Zoom.
Yeah. It's actually a lost evidence issue, Your Honor. It's not a, oh, gee, we can't open it issue.
Yeah.
It's gone. I think they lost the evidence. And for whatever reason, the attachment has been taken away on the other end, okay? So this is a real bit of prejudice and a distinct bit of harm to the defense that Ms. Peter, who is a government agent, who's provided, and we'll get to this.
Let me just
false
ask Mr. Cosgrove before you go into all of that.
Sure.
Mr. Cosgrove, to the best of your knowledge, has that been turned over to Mr. Bradel and Mr. Betterow?
Has what been turned over?
Has any of the attachments that Mr. Bradel has just referred to?
Depending on what the attachment is, some of the attachments are visible simply by clicking on it. Others that specifically Mr. Betterow has inquired about, to the extent that I can resurrect them, I have sent them along to him and will continue to do that. I haven't worked my way entirely through his letter. But what happened, Your Honor, is this. Lieutenant Tully, who was the recipient of most of these, has the practice of not clicking on unsolicited links that are sent to him on email, so he doesn't access them. Now, if someone is sending him a reference to something that is online, he may check with that person and ask the person, where can I find it online? And then he will go himself and look for it online. For example, Mr. Kearney's YouTube presentations that were introduced to the grand jury. All of those were things that Lieutenant Tully found himself online. He may have been pointed to them by Ms. Peter. He may have been pointed to them by one of the alleged victims who complained about them. May have been pointed to them by multiple sources. But he never clicked on whatever it was that was sent, in part because he's working off a computer system, an office computer system, and there's caution about infecting it with unsolicited links. So these were never accessed, in effect, by the Commonwealth. If the links are now dead, we've never seen them. The links are dead presumably because whoever sent them took them off the internet. So,
This would be some text from somebody with a link to a video or something else. And so you'd have the text, but not what the attachment is?
you'd have the text, you'd have a link to a video.
I get it. Okay.
You click on the link now and
Yeah.
nothing happens. Whether if Lieutenant Tully had clicked on the link
Right.
6 months or a year or 18 months, it would have taken him somewhere. Probably would, but he didn't.
Okay. Gotcha. All right. Mr. Bradle.
A couple of things, Your Honor.
Go ahead.
A bit of a red herring to kind of suggest that, oh, some crazy person from the internet is sending me something and I don't want to look at it. That's not this. This is a government agent, Catherine Peter, sending them stuff that she's working with them. And you know, you mentioned an evidentiary hearing the other day, Judge. I think we should have an evidentiary hearing on this discovery stuff. Let's bring in Mrs. Peter and let's find this stuff because this is important stuff, and I'll tell you why in a second. But this isn't some unknown person. This is someone who repeatedly emails the state police and Mr. Mello, so in other words, and the government and the prosecution and the Commonwealth, and is actively assisting the Commonwealth, providing links to certain things. So they're gone. And so let me just jump ahead. One of the things that's missing is Ms. Peter, and we know this from the new emails that we got last night. Ms. Peter changed the titles of Mr. Kearney's shows that were these 4-hour shows, Your Honor, that had innocent titles, like, you know, for example, Karen Reed case, where's Michael Proctor? Amiri King wants to fight Turtleboy, Canton updates, Anti-Bev Canoni out of control. So it's a title that encapsulates a 4-hour show. That was his work. Ms. Peter changed those titles, provided it to the Commonwealth, told Lieutenant Tully in the emails that we have about changing the titles, so they knew. And then they put those titles in as exhibits. We found this out, of course, after the McCarthy-Odell motion. And these titles are different. These titles are very incriminatory, and they suggest they impact Mr. Kearney's alleged intent to intimidate witnesses. The titles were all changed, and I can proffer up a spreadsheet of the actual titles and then what she changed them to in these attachments that, oh, gee, now we can't open them. So do the math on that, if I may approach, Sean.
Yeah, sure. Thanks, John.
And so we have now learned that we have a grand jury that was listening to these video clips with titles like, you know, I'm going to kick Colin Albert's ass. And that's just me paraphrasing, but nasty titles. Give me another copy of this one. Yeah. Trying to destroy Colin's life. The actual title is Commonwealth tells more lies about John O'Keefe's GPS data. That's his real title. And these were suggested to be Mr. Kearney's expressions, which of course would be used as his bad intent. And they're false and they're lies, and they were done, and we know this from the emails, from this Catherine Peter person.
Yeah, but so what does this have to do with?
So these are attachments that we can't open. There's an example of attachments that are exculpatory and incriminatory to the Commonwealth that we can't even open. So
these YouTube, so on the side of the document where it has the link, your allegation is that you can't open up any of these.
No, I'm sorry. That's if you wanted to see for yourself. But the other two columns are what Ms. Peter made those titles.
Yeah, no, I get that.
And then the regular title.
She changed.
And that was used.
This document, she changed.
That was published to the grand jury as Mr. Kearney's work. And it was even argued in Mr. Cosgrove's, one of his recent filings, he argued that, about how these things are so aptly titled, is what he wrote. You may remember that. And this is all false evidence.
Okay.
So you know, this
What
is,
you're looking for us to do with it, though?
I'm looking to ask to take you up on your offer to have a hearing on an evidentiary hearing where we bring these people in and we get to the bottom of how Ms. Peters' work for the Commonwealth went. And that also impacts, and see, this is all interrelated, Judge. We want Attorney Mello on the stand for this too, because he's the one that presented this false evidence
File a motion
to the grand
for all
jury.
this. I'll take a look at whatever you file, but I think we're kind of getting off track a little bit in terms of what the
Yep.
Commonwealth owes you. That's what I'm concerned.
Okay, I know, I hear what you're saying on that
Yeah.
issue, but we did file a motion to disqualify Mello, who's been, you know, not able allegedly to be here, but he can be on Zoom. Whenever there's a hearing where Mr. Kearney's bail might get revoked, he's right on the Zoom watching. But, you know, that's another thing we'd like to do here today, is ask the court to schedule an evidentiary hearing on
Gotta write a motion.
No, we did, Judge, I filed two.
For an evidentiary hearing? Is it
Yeah.
a new one?
Yes, a motion to disqualify. We have two pending. In fact, Judge Rayburn, I believe it was, set the hearing, and he alleged that he was sick and couldn't come, and it's been in abeyance forever. So we have, Judge. I don't want to, you know,
When
bury
did
the
I talk
court.
to you with Mr. Crosby?
Sure. So you see, Judge, how everything's interrelated. And with respect to the disqualification issue, this is another issue where Mello's involved in this, what we would contend is a conspiracy to put false evidence in front of the grand jury that we figured out. And it was used and argued it was a misrepresentation of Mr. Kearney's intent. Because when you would put a title like that on something.
So this is what I'm trying to get you back to, though, Mr.
All right, go ahead, Judge.
What do you need? What else do you say that Mr. Cosgrove has as the special prosecutor that he hasn't turned over to you? We went through that list of items. I just want to get you back on track.
Sure, okay. So Judge, there's a November 1st email that we can't get the links off of that, and that's important. If I could just have one moment.
Yeah.
That's the exact email with the links to this, fake links to this that we can't open. And it's not a thing like, it's not a thing where, oh, well, let's go back to the office and fix it. It literally says, Google Docs, it says, sorry, the file you have requested does not exist. So it's gone.
Okay.
So why did this person make it go away? And I think we know why, but that's why I want to ask you for that hearing too. But, so we want the government to, in writing, tell us what links they have and what links, where did they go? We want them to respond in writing to why there's lost evidence.
Okay, let me just talk to Mr.
They have what we have, and they can figure out where they went to the same extent that the Commonwealth can. The Commonwealth has not deleted any links.
All right, I'll take that under advisement. What else you got?
It says, Judge, literally, the files have been deleted.
Okay.
It doesn't say they've been deleted by the Commonwealth.
So would the court consider ordering the Commonwealth to, we'll tell them what links we can't open, and they need to give some sort of an explanation why this is lost evidence.
Why don't you give us a list of the links that can't be opened?
All right, thank you.
And send it to Mr. Cosgrove, and Mr. Cosgrove, but just ask perhaps if you give us an explanation as to why they can't be opened.
Sure, I will give you,
Yeah.
I will give you an explanation. I will consult with our experts,
Yeah.
but I can almost guarantee, Your Honor, that the explanation is going to be that whoever is at the other end of the link removes the content.
That very well might be it, but I think it would, I think if it was in writing, it would probably be better.
Yeah, I'm happy to do that, Your Honor.
That's great. What else, Mr. Grader? What else?
So Judge, we talked about the Kearney extracted, redacted extraction, excuse me. So can I get a copy of that? We don't have it. We've been looking for it for 9 months. Can you order?
What is it, the redacted?
The redacted extraction
Okay.
of her phone.
But you had the document at one point in time.
We had it. Judge Krupp ordered us to destroy it and give it back, which we did.
Yeah.
And just 9 months
You
ago, we
haven't
never got
gotten
it back.
the redaction back.
Right.
Okay. Mr. Cosgrove.
I object.
Okay. Tell me why.
Well, there's a long history on this, Your Honor, and I went into it in one of my memoranda at length. In the original course, the Commonwealth and the defense entered into an agreement that they would return the original extraction and that we would provide them with a redacted version limited to those things that we felt they were entitled to under Rule 14. I asked Lieutenant Tully to prepare that. He did that. I sent Mr. Bradel a notice. I don't recall when, but the date is in my memorandum saying it's available at the office. Come over, pick it up, or let us know how you want to get it. And I believe I also indicated that there was some additional material on the thumb drive with that extraction. Mr. Bradel never picked it up. In the meantime, came back to court for various reasons that are, I believe, still presently impounded, although I believe Mr. Kearney referred to them on one of his YouTube shows. For various reasons, Mr. Bradel indicated that he needed to keep the original thumb drive. Those reasons were unrelated to any issues in this case, but I was persuaded that he should be able to do that at least temporarily. We struck an agreement with respect to the use of that thumb drive, and there was a subsequent reduction of that or a modification of that to writing at Mr. Bradel's request that was endorsed by the court. And then in the Commonwealth's view, which the defense, I believe, still disputes, Mr. Kearney immediately went out and violated those restrictions. So I then filed a motion in front of Judge Krupp requesting an order that the thumb drive be returned. Now, at that point, Your Honor, the defense had the full unredacted thumb drive in its possession, custody, and control for some 9 months. Mr. Kearney had publicly stated on his YouTube presentations that he had provided the contents, a duplicate of the contents of that thumb drive to any number of other people. But the physical thumb drive was ordered returned by Judge Krupp, and it was returned. In the meantime, the defendant had been presenting what I would consider to be various material irrelevant to the case, designed to embarrass and humiliate Ms. Kearney. There was a reference, for example, to her DoorDash orders. There was the defendant picking out a phone number more or less at random and said, well, here's a number that she apparently calls a lot. Let's see who this is, and calling out the number live and dialing it live on his YouTube show. There was a reference to her ex-husband's daughters, if I have it correctly, and what they thought of Ms. Catani, so forth and so on. Judge Krupp allowed that motion at a provision that I agreed to, but I think was initially suggested by Mr. Bradle. The defense was allowed 2 weeks before they turned the thumb drive over, or approximately that amount, to take notes on anything they thought was relevant on the thumb drive, and then it was returned. As far as I'm concerned, they had it. They had an opportunity to examine it. I assume they did examine it. If they have time to go into the kind of trivia and side roads that Mr. Kearney went on to. I don't think at this point that the Commonwealth has an obligation to jump through further hoops and reprovide them with a different version.
All right, I'll take that under advisement.
May I be heard on that, Judge?
I think you already were. But I'll give you 30 seconds. Go ahead.
Yeah, Judge, there's no violation. If there was a violation by my client, I say bring it on. There's never been an allegation of a violation. If there was a violation, you know this Commonwealth would have done something about it. There was never a violation. They agreed to give it back. We don't have it. We were allowed to take note of it, but we were ordered by Judge Krupp to destroy it and not have any of it until we got the redacted one back.
Let me ask you this. Did you have it for 9 months?
Yes.
Thereabouts?
Yes.
Did you have a chance to look at it?
Yes, we looked at it, but we were told to destroy it. We don't have any evidence from it. It's destroyed. We were told, ordered by Judge Krupp to destroy it. We need another copy of it. We need the extracted copy of it.
You need the redacted copy.
Hey, we're happy to take the redacted copy,
That's
of course.
fine. All right, under advisement.
All
What
right,
else you
thank
got, Mr. Bradle?
Judge, so just have one moment, please.
Yeah, no, take your time.
Judge, impoundment. As I alluded to earlier, the fact that the sovereign of the special prosecutor here has already released much of the items that government here is trying to keep private, I think it's completely.
Are these impounded or under a protective order?
Judge, I would say that I don't think it matters, Judge.
I think legally it does, doesn't it?
Well, it's a similar examination, Judge. Okay, it's a protective order. Things are impounded by either a judicial order keeping judicial documents private, or you could say, and I think the parlance is that if something is under a protective order, it's impounded from view from people.
Right.
So I think it's just sort of a parlance issue. I think, frankly, the government was splitting hairs when it was trying to say
But
that.
you have all the documents, right? Everything that's under a protective order, you have as Mr. Kearney's lawyer.
Judge, we have the documents that are under protective order, because as I alluded to last time, you know, we're sort of under the gun of having to agree to it to get them, and we need these documents. So at the time, but this is a serious deprivation of the public's rights to know, Judge. The public is the victim here. And, you know, these are documents that are kept private for no good reason. Whether it's, you want to call it an impoundment or a protective order, there's no legal basis for it, Your Honor. As I said last time, things that show government malfeasance.
What's the basis for a protective order, though? We were discussing that today. Do you have any case law that you could point to on exactly what it is that the government, the hoops that they have to jump through to get a protective order?
Judge, I filed 8 pages on it last time.
Yeah, but give me some of the cases that you think are the most important. Because that was actually something we were working on today, trying to.
Well, Judge, the first order of business on that is that the burden's on the Commonwealth here.
Yeah, no, I agree.
So,
I agree.
you know,
maybe I should ask that question to Mr. Cosgrove. But I'll ask it to you first, and then I'll go to Mr. Cosgrove, because the burden is on the Commonwealth. I agree with that. But these protective orders are already in place. So I understand you have the constitutional argument that you and Mr. Betterow have profit about the public's right to know. I get that part. But just in terms of a practical,
Thank you.
Yeah.
1 second, please, Your Honor.
Yeah. No, take your time.
So, Judge, paragraph 3 of my filing last time, Aidan Kearney's motion to release case documents from impoundment. Paragraph 3, New England Internet Cafe LLC versus Clerk of Superior Court, Suffolk County, 462 Mass 76. Public has a right of access to judicial documents and a right to understand and observe the operation and work of the judicial branch. They're presumptively public documents. There's a common law right of access to judicial records. So that's sort of that's where we start, is that these records need to be in the public's view. And so the burden is on the government to say why. And then just to carry through, just going to allude to what I said last time, is that when there's corruption or malfeasance, embarrassment, that's not a reason to hide documents from the public. That's the reason to show the documents to the public of the government's missteps. And in this case, there's been a lot of them. And that's really what the government is saying, like, oh, we can't have Mr. Proctor's emails because there's a safety issue. You know, there's always a safety issue. It's either children or a safety issue. There's no safety issue. There's no children involved. It's just embarrassment. He's well on record to show all sorts of horrible things that he's said in his texts or emails or wherever. But so the idea that we're going to hide any more of it is ridiculous. And the other issue, Judge, is that of the ones that we get, there's never the full story. There's like one screenshot of someone's text, and then there's no responses. There's no, you know, there's just a one little thing that they hope we're going to look at and be satisfied with. There's never any context to this stuff. So that's another discovery aspect.
Let me give the floor to Mr. Cosgrove then about the protective orders. I agree with your filings, Mr. Cosgrove, that these are protective orders as opposed to impounded. So I'll start with that.
All right, Your Honor, and let me just say, as I previously indicated, the release of certain public records is new to me. If Mr. Bradel wants to go through the public records that were released and compare them with the material that is presently under protective order and identify any of those particular things, I'm happy to assent to their release from the protective order, because obviously if they're out there, they're out there, and the protective order isn't really serving any purpose as to those particular materials. Now, with that said, in terms of cases, Your Honor, I would direct Your Honor's attention to the case law in particular cited on page 2 and 3 of my brief that talks about the validity of discovery orders in terms of discovery protective orders as opposed to things that are actually documents filed with the court. I think that's the pertinent case law to direct you to.
Okay.
I would also, Your Honor, like to direct you, if I could, to a YouTube presentation, which is essentially a commentary on the opposition I filed. Mr. Kearney did about an hour and 10 minutes of his own commentary on my filing. It's in YouTube episode 795, entitled, and I'll leave it to the defense to correct me if I get the title wrong, Cosgrove Gets Frisky, What Happened on the Cape, Twitter Shenanigans. And if you start at about 141 at that presentation, and if you can stand it, Your Honor, follow through to about 350, you'll hear Mr. Kearney's explanation as to what he wants these matters released for. And I would characterize his comments somewhat tendentiously as saying, apart from some quibbles about whether I got the titles of his YouTube shows correctly, Mr. Kearney's response is, everything Cosgrove says I want to do with these documents is exactly what I want to do, and so what?
Okay.
Well, Judge, if you look at my filing, there's about 35 cases in there that talk about all this stuff dead on point. And there's no Turtleboy exception to the First Amendment, okay? Everybody out there has got this stuff, and Mr. Kearney is not allowed to look at it or use it. It's ridiculous. Every journalist on Twitter is citing this stuff, and he's got to sit here. The guy that broke half of the stuff in the Karen Reed case, he's got to sit here and not touch it and not do anything. It's ridiculous. It's totally abhorrent. And
So these 400 things that were released on the FOIA request.
4,000.
4,000. 4,000. Oh. Do you have a copy of those?
Everybody's got a copy of those.
Yeah.
I don't have a copy, Your Honor, but I assume I could get it.
I'm not surprised.
All right. Perhaps, I know it's voluminous, but,
We can give you a link, Judge. It's easy. It's nothing.
okay.
You like a link?
Yeah, that's fine. If you could just maybe write it out.
No problem.
All right. Do we have anything else?
We do, Judge. I'm sorry.
What else we got?
Spot here today.
I just would like to make one more submission.
Yeah, go right ahead.
With respect to the issue that we're on. One of the points that I made, Your Honor, in my memorandum is that there's a cycle here, which is that Mr. Kearney continues to post things about the witnesses in his case and the Karen Reed case on a regular basis. That provokes typically the witnesses to complain to the district attorney's office. That generates statements which need to be turned over in discovery. And I made the point that turning over much of this material, I don't know what public interest there is, for example, in an email where someone says she received an anonymous threatening phone call, which she attributes to a Kearney post, whether rightly or wrongly, other than to, I just don't know what the public interest is in that kind of thing. The public does not have an interest in going through everybody's cell phone, underwear drawer, et cetera, et cetera. So just to drive home the point that Mr. Kearney is continuing on a almost daily basis to publish tendentious commentary about these people, I want to call to Your Honor's attention something that came to my attention this morning that he posted 24 hours ago. If I could.
Yeah, let me take a look at it. Thank you.
I think he missed a few of his usual targets, but most of them are there. I'm not suggesting that this is a violation. I'm not suggesting that it's criminally actionable. I am suggesting that it would help Your Honor conceptualize the use that he's going to make to any of this material that's under protective order.
Okay. I looked at it. I get the point.
All right, that's all I have, Your Honor.
All right. Mr. Brito, what else you got?
Judge, I can, just watching you peruse Mr. Kearney's publications, okay? Thomas Paine, Samuel Adams, Mark Twain would be spinning in their graves if they saw that a judge was looking at First Amendment protected satire, jokes, criticism, as if there's some risk that this stuff should be sanctionable. It's just completely antithetical to the First Amendment, Your Honor.
Okay, I don't want Mark Twain to feel poorly about me.
Really.
So,
Judge, it's just ridiculous that the government proffers that as some sort of evidence of something is just completely beyond the pale, okay? This is all First Amendment protected.
I get your point. I get your point.
So
You've made it very well.
So there's a few more things, Judge, about this impounding these.
The impoundment I get. So I get your arguments on that.
One little
Do you
fact.
have any other discovery issues?
Yes.
What else
Can
you
I
got?
give you one quick fact?
Yeah.
These people that the government is trying to protect with these impoundment orders that they need, or protective orders, they're doing interviews. The McCabe, the Alberts, Proctor, they've all done nationwide interviews. And yet the government wants to say, oh, we need to protect them from safety because of keep their stuff private. They're doing interviews. So that ship has sailed, Your Honor. All of their stuff needs to be unimpounded for our use, for our ability to use it without these constraints, and for the public's right to know, Judge. It just needs to be out there. There's no reason to keep it.
No, I get your point. All right. Is there any other pieces of discovery that you want to argue about? Because I have, I got some other things we have to do, some other cases. We have 2 other cases left. Mr. Bradle, I don't want to rush you, but
going back to the Mello issue, Judge. So Prosecutor Mello was the one that was working with Ms. Peter on these phony clips. And we need his emails too on this stuff. And I hope you're not going to say, oh, okay, file a Rule 17. Because I did that with respect to Morrissey's emails. And I was told by Judge Krupp, and I think it's the law of the case now, that no, that's a Rule 14 issue because it's in the possession of the prosecuting authority. So it should be Rule 14 discovery that Mello is communicating with Kate Peter, and it's been undisputed and it's been revealed in this case 100% that Mello's been talking on the phone with the other complainant here, Gattani, and we have only incomplete screenshots and inconsistent screenshots with respect to what's on the phones versus what really happened. And we need a written explanation from the government as to why there's inconsistencies in the discovery, and I'll tell you what that is in a second. But also, we need the full text report. We have these cherry-picked little texts, and like I said before, it's obvious that it was a string, and we get like one email with no responses or no prior context. And it's like they're hoping we just go away if they give us one thing. But it's not, the context isn't there, the full email strings aren't there. And we've made this complaint many times and it doesn't go anywhere. So I'd ask that you order the Commonwealth to either give us the stuff or respond in writing why they can't find it, don't know what I'm talking about, or whatever their position's going to be.
these are the Mello emails you're talking about?
So we want Mello emails because he's talking directly to Gattani and Peter.
Yeah.
And we have a couple snippets of them, but it's clear there's other ones from the context that we don't have.
All right, I got you.
Yep, thank you.
All right, Mr. Cosgrove.
Well, I believe I turned over the Mello emails in the last round of discovery, and that generated a chiding letter from Mr. Betterow saying that you've had these for a couple of months now. We should have got them sooner. So I'm not, so far as I know, they have the Mello emails.
Right.
Okay. That being said, I think we should pick another date.
So Judge, just the last thing on that. If
Yeah, no, go ahead.
Sorry.
No, go ahead. That's fine.
For example, Judge, there's a very important group text between Morrissey, Proctor, Tully, and others. And we have like one email from them that points up an extremely provocative issue relative to Proctor saying, why don't we just arrest them about my client? And there's no other discovery on it. There's a perfect example of cherry picking, why we need answers on this stuff. We need more. And there's also, Judge, there's inconsistencies in what we were given, where there'll be, and here's my last thing. Well, there's a list of text messages from discovery that we've been given, And then online, Ms. Peter, it's related to this Ms. Peter again, she publishes a string of text. It's the same string, and there's more emails, or there's more text in her string that she published online than in the discovery we got. So it's kind of a smoking gun that something was taken out of the discovery we got out of an extraction. And sure enough, we checked with Celebrate, the extractor has that ability to unclick a box to deprive the recipient of something, and the recipient has no idea. So there's a smoking gun here, Judge, that's why this isn't a normal case. I don't think you've ever heard me talking this deep about getting discovery. And here we are because of real reasons, Your Honor. And I hope that the court can give us this relief.
Okay.
Thank you.
All right, why don't we pick a date or anything further that you might have?
Does the court want to suggest a date? I haven't had too much luck suggesting dates myself lately.
We think September?
So, Judge, in the meantime, would the court order production of some of those written responses? And
Yeah, I'll issue an order on the written responses.
thank you.
I'm sorry, what written response?
I think he's asked you to give written responses as to, for instance, the links and things like that, what can be open, what can't.
Oh, yes. Well, I just indicate that Your Honor indicated that Mr. Breda was going to provide me with a list that I would respond to, so I would just hope your order would take that into account.
Fair enough, Mr. Cosgrove, fair enough.
And Judge, just to the suggestion that, we should tell him what links we can't open. We can't open a single link. There you go. Compliance.
All right. Give me a date that works for the both of you.
September.
24th, 25th?
I can't do the 25th.
24th is fine.
Okay, that'll be at 2 p.m.
We'll see you on September 24th at 2.
Okay, Mr. Kearney, your cases are continued to September 24th at 2 p.m. for further discovery.
Okay, thank you all.
Thank you. I know, I was going to say the first one with the prior restraint. Yeah.
We get 88 cooks.
Like, that's what he means. It's so, oh, that's just, it's so ridiculous. That, like,
never around.
Okay. Well, we also need,
that he would cite that as some sort of problem. She can.
or Ethan, he's not here.
Can't be calling. No.
We need 88 cooks. Homobia. Hopefully we do that first, that'll be quick. Thank you. Okay, so we're going to call number 3. Como versus Abdul Magasa, 22 CR 252. Mr. Magasa is present, represented by Attorney Aidan Yankowitz. The Commonwealth is represented by Assistant District Attorney Sean Riley. Matters up for motion hearing. If you could please identify yourself for the record.
Good afternoon, Your Honor. Sean Riley for the Commonwealth.
Good afternoon.
Good afternoon, Ethan Yankowitz for Abdul Magasa. He's present.
All right, good afternoon. I've read the filings. Let me see if I can sum it up. So the government has a knife. The first blush, the government says that there's 5 sources of DNA. Second blush, they say that it's 4 sources, and because it's 4, they can now do some tests, and it comes back to the defendant. Is that generally correct?
Yes. Generally.
Generally?
Yes.
Generally correct. All right. So I'm going to start with Mr. Yankowitz. I can give you a little bit of history of DNA. So back when DNA first came to the forefront, there was a whole series of DNA hearings that were conducted in Suffolk County. Elliot Weinstein and Larry Tipton represented the defendants. And it had to do with the admissibility of DNA in Massachusetts. This was about 1995. I forget the name of the case.
I am losing my mind, guys. Ha! That hearing made me crazy. And at the last 5 minutes, I missed because my son's doctor finally called, what I've been trying to get done for 2 days. I had to talk to her about. So, I'm here. Hey, Rosie. Hey, Lucas. It's good to see you. If anybody is just irritated as I am, because he was like, I like Judge Doolin, but today I feel like he was not in his zone. So I think it was odd. And I feel like I don't really feel like anything got accomplished today. We've missed your face, Lucas. I feel like nothing got accomplished at all today, honestly. But so I am gonna have to get off now because I have to go and make a phone call back to another doctor's office. I've been on the phone literally for 2 days for doctor's offices, just trying to get my child into ABA therapy again for his behavior, because he's so big and he can overpower me. And I'm trying to get him an AAC device because his doesn't work anymore and is 7 years old. And Wayne, you're right. Nothing at all happened in that court today. I literally, Mark was busy. Okay. I hear ya. Mark. It's an AAC device. It's spelled AAC. So it is a communication device for Liam, so that he can actually communicate more than just 1 or 2 words at a time, even though I can understand him and Steve can understand him and some of our friends can understand him. This will be, it's like an iPad where it's got little tiles on it and it has different things, so he can talk more and actually have a conversation with us. And he can actually tell us when he's hurt or what hurts, where it hurts. And he can use it at school too to make him do it. We've had one for 7 years. It's just old. And it doesn't even want to hold a battery anymore. So it was right there. Didn't miss much, just more. Cosgrove needs oxygen. Okay, next time somebody needs to bring an oxygen machine for him, because I thought he was going to pass out. And yes, I love that word, malarkey. It was a bunch of malarkey today. That's what it was. Malarkey has been my last 2 days. Okay, it took me. So I've been trying to get these referrals from his doctor since last Thursday. And I have called numerous times. I have left messages. I have sent messages through my chart. I have stopped in there this morning. I literally went there myself this morning to get Liam's stuff and get his referrals, and it didn't work. And then for myself, I've been trying to get my medication, and I stamped my foot. Zach, you taught me how to do it the best. That's how I did it, and it didn't work. It wasn't until this afternoon, when I was before I came on live, that I was picking Declan up from school, and I called and they were like, oh, well, you need orders from whoever's ordering it. And I was like, I'm ordering it. I'm his mother. I want him back in his therapies because when he's in therapy, he does better like normal people do with therapy. And they were like, oh, yep, an AAC device. Let me see if I can find one for you. Let's see what you guys can. It's an augmentative and alternative communication device. Let's see what you guys, if I have one up here, and you can see what it is. So this is what it is. If you guys can see that. They want a better. You were just looking at old doctor, not visit. I'm part of the Phillips C. Pop case. I'll have to look that up and see. Yeah, so this is to help Liam tell us more so we can understand him. Because yes, I can understand when he wants something. Like if he wants chips, I can understand when he wants the old CPAPs, yeah. I can understand those things, like little things. He can tell me little things. I have a video. Let me see if I can find it. I'll show you guys. It's Liam talking, but I love this video. It just happened the other day. I don't know if I showed it to you guys or not. Yeah, here it is. Let me see. Show options, all files. So this is Liam, you guys. This is my son Liam. This is him asking for something. You'll hear me repeat what he says, and it's only because we finally figured out what he wants when he asks for it this way, and it's just this thing that we know. So, but not all things do we understand. There's times it took us 3 days to figure out he had a tooth that was hurting him and he had to have surgery. So, and we ended up had to drive 3 hours to get to Shands because they're the only dentist that would take it. And now I found a dentist that's literally a block from me who will take his insurance. So she said she would work with him. But this poor boy, I say poor boy, but he is so happy. He literally has, since he was diagnosed with autism and cancer and epilepsy, he has been through so much and more than most adults can handle. And I will tell you that the toothache that he had, the dentist told me that a grown man would have been on the floor and you could not even tell that it was bothering him except he wouldn't eat. That's the only thing we knew is that he wasn't eating. And we had to figure out why. And so it wasn't until we tried everything and ended up putting in a toothbrush in his mouth and he jumped backward. And that's how I knew. And that was at 6 a.m. And I called at 8 a.m. They had us in at 1 and we were admitted to the hospital overnight for him to be seen for a surgery to have it removed. But we had no idea that they would let us or do it. So
Jack, you wait, die, juggler, Alexa.
You want I Was Jack and You Were Diane by Jake Owen?
Alexa.
On Alexa? Okay.
So that's one of him asking, like that's a sentence for Liam. But if you didn't know what he was saying, you would have had never. Exactly, Lindsay. If we wouldn't have caught it when we did, we would have never known. And they said a grown man would have been on the floor in pain. They had no idea how he wasn't. No, Rozzy, he says, I Was Jack and You Were Diane by Jake Owen on Alexa is what he's asking. So you can hear all that.
Jack, you wait, die, juggler, Alexa.
You want I Was Jack and You Were Diane by Jake Owen?
Alexa.
On Alexa? Okay.
So I don't know if you could hear it better, but yeah, he said, I was Jack and you were Diane on Alexa. That's one of his favorite songs because Liam likes country music. And lately he's been listening to Troubadour by George Strait. And I'm like, if you ruin this song for me, I will come after you because it is one of my favorite songs. And this child will play a song to death. You know what's funny, Lindsay? He has had a love for country music since he was a newborn. And only reason I know is because there's a, here, let me remove this. I'll show you. There's a song, there is a song that he loves, and it is, you guys know Travis Tritt, of course, right? Hopefully everybody knows Travis Tritt. Let me get it up here. All right. So Travis Tritt and his daughter, Tyler Reese. All right. So if you know Travis Tritt, you'll know the girl I grew up with is married to Travis Tritt. They have 3 babies together. They're not babies anymore. They're all adults. And so I had a song that had been released prior to them actually releasing it. I had downloaded it when they gave us the Kiki gave us the pre-order to download it because we all grew up with her. And so when Liam was born, I was driving to we were going to get a Christmas tree. And he would not stop crying. I think he was 4 weeks old, and he would not stop crying. Liam, turn it down, please, buddy. Everyone doesn't want to hear Mickey. Turn it down. So we were driving about 45 minutes to go get a Christmas tree, and we were like in 2 different cars because we had all the kids and friends and stuff. We were doing it together, and they had a bunch of stuff out there at the Christmas tree farm. And he was like 3 weeks old, and I could not get this boy to stop crying. And then I played this song, and this boy he stopped crying instantly. And all of our trips to Lakeland, because my son, my kids are with their dad, played this song, and we're gonna get banned, but you can't. So it is Sometimes Love Just Ain't Enough, that 80s song. Him and his daughter released it together. They are amazing. Tyler is on her own now. Tyler Reese Tritt is doing her own music. And she's touring, like opening acts for people now. She's doing a lot of stuff where they live in Georgia as well. And I started that, and Liam was at the kitchen table. When I started that, he just came over here, stood over me. He was like, hi. So, but yeah, I'll play a little bit of it so you guys can see. There's a danger in loving somebody too much, and it's sad when you know it's your heart you can't trust. There's a reason why people don't stay where they are. Baby, sometimes love just ain't enough. I could never change you, and I don't want. So what I will tell you is that Tyler looks like her dad, but she looks like her mom too. So let me see if I can find where there's Kiki's in here. Her name's actually Teresa, but we've called her Kiki her whole life. Let me see where she is. Where is she at? I don't want to pull up on my Facebook because I don't want to give away her Facebook. Well, I'll do this. Travis. There's their wedding picture right here. How funny is this? This is their wedding picture, you guys. Where is it? That's their wedding picture. So I grew up with Teresa. She goes by Kiki. But Liam is addicted to that song. And it's been since he was 3 weeks old. So he's 11 now, and he literally just came flying over to see it when I played it. And that was just the first part of it. And people will write me and they're like, Kelly, is he still like that country song? I'm like, yes, it's the only song I couldn't drive anywhere without that song. Like, we would play it on repeat over and over and over and over and over. But it's worth it. So this is, let me see if I can show you. This is them. This is them now. It's Teresa. And then they
How am I supposed to say that? Talk time with Amy in Boston and Kelly. time with Amy, Boston and Kelly. Talk 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 time with Amy, Boston and Kelly is a member, y'all. Is a member, y'all, to the Gene Deal Show. Talk time with Amy in Boston and Kelly. Talk time with Amy, Boston and Kelly. Talk time with Amy, Boston and Kelly is a member to the Gene Deal Show. Oh, thank you for your membership. Talk time with Amy and Boston and Kelly on the Gene.